All rise.
Yes.
Just before the lunch, Chairman, my Lord Brown was putting to me that if there were joint sponsors, there might be a problem under 3174 if one of them lived in London and one of them, say, in Birmingham. But it's enough that the person coming here is to live in accommodation which the sponsor owns or occupies exclusively. It doesn't matter where the sponsor lives. Where the sponsor lives is immaterial for the purposes of 317 Roman 4.
I thought I was worried about two. You've got to be joining. Are you joining them if you go and live a few hundred miles away?
Joining or accompanying a person who's present, settle, the same occasion being. Well, in my submission, joining doesn't mean you have to live in the same house.
No, I mean, I'm persuaded of that, but can you join them at 100 miles distant or 400 miles distant?
Well, it may
we don't have to decide it.
You see them every Saturday through to Monday.
Yeah. But in two, singular means singular.
Yes.
It doesn't have to be read to include the plural.
Yeah.
Accompanying, though, you may accompany a person, but not stay with them forever. Perhaps it's not helpful to speculate on the various possibilities that might arise.
I think, being admitted.
Accompanying, presumably you come along with them. You're coming with them.
Yeah.
But it'd be very strange indeed if the person who's coming here may intend to live with or nearby the person that they're joining, but they may then, very quickly, for good reason, move somewhere else because of entirely proper family reasons. There may be another relative who they go to care for who lives some miles away.
I mean, what happens if they get a girlfriend or something like that? I mean they're over age 18, the sons and daughters and so on. Financial, whatever. Yeah, job, whatever.
Indeed. May I turn to Lord Hope's question, my Lord Deputy President's question to me? My Lord put to me the finding made at page 41 of the appendix, paragraph 32, here dealing with the application of 317 Roman 3. And the immigration judge, the senior immigration judge, Judge Molden, on the reconsideration, suggested that the money sent to the applicant in Ethiopia did not come from the daughter, but it came from the granddaughter.
Yes.
That's the finding. Well, the answer is that, in fact, on the factual findings, it was the daughter in the UK, that's Anab, who sent the money, although the money, in fact, was given to her for this purpose by the granddaughter. I say that because if we go to page 48, which were the findings made by Immigration Judge Bolger, who, of course, heard the evidence, that's what he finds. If we go to appendix page 48, paragraph 20, he finds, with regard to dependency, the sponsor's evidence was that since she, that's Anab, had discovered her mother's whereabouts, that's in Ethiopia, she had been sending the appellant monthly remittances of about $100 to cover the rent of her mother and the granddaughter for their room and their living expenses. The money was sent through an organisation, that's a money-sending organisation, money-changing organisation, operating in the Somali community. And at paragraph 21, the immigration judge says in the middle of the paragraph he's satisfied as to the remittances sent to the appellant by or on behalf of the sponsor. So the facts, and of course, Senior Immigration Judge Malden heard no further evidence. He didn't hear any further evidence.
No.
So the finding is that the money is in fact sent to Ethiopia by Anab, the daughter, but the money is provided to Anab by the granddaughter, Ayan. She's the one who obtains the money.
And on behalf of is good enough.
Yes, in my submission, because we say for the purposes of 3173, the appellant in Ethiopia is dependent on the sums that are sent to her by her daughter in London, by Anab.
I think on behalf of there simply is a reference to the money-changing organisation, isn't it? Paragraph 20.
Yes, I think your lordship must be right. Yes, I think that's right. Yes. Yes. But what is good enough in order to satisfy sub-rule 3 is that the person who sends the money to Ethiopia is the daughter, Anab. It cannot, in my submission, matter whether she obtains that money each week from her own daughter, Ayan, or from an employer, or from a trust fund. In my submission, it is completely irrelevant for those purposes how she gets the money. The facts of this case are that she sends it.
So a conduit would be all right, would it, if in fact the transmitter is the sponsor? So long
in my submission, yes.
There's no particular objection
case
to a conduit in this context, you say?
No, there's no conduit because the person who sends the money is the sponsor. It is the daughter, Anab. She has in her hands the money which she sends every week or every month to Ethiopia, and that makes the appellant KA in Ethiopia dependent upon her, dependent on the money that she sends. How she gets that money each month to send it on is completely irrelevant. As I say, she may get it from an employer, she may get it from a trust fund, she may get it from a relative. There may be other means by which money is properly obtained by people. The rule is simply not concerned with that.
Is this assuming that we're not treating the granddaughter as a co-sponsor?
Yeah, indeed.
Which the judge does in 24. I mean, 24.
Absolutely.
Yes.
The first answer is on the facts of this case, which is what my Lord the Deputy President was asking about. This is a case that on the narrowest possible interpretation, we satisfy the rule. If that's wrong, then I do say that it's good enough that we have here, on the facts of this case, as a matter of substance, co-sponsors. That's good enough. If that's not good enough, I say that in any event, Rule 317 Roman 3 should be interpreted in the way for which Mr. Gill contends, so as not to exclude money that comes through a third party relative. That's Mr. Gill's submission. If necessary, I adopt his approach. I also submit that this point was not taken against us in the Court of Appeal judgment, and it's not raised in the ECO's printed case.
No, you're quite right. The Court of Appeal, I think, were in some doubt as to exactly how the point had been argued,
yes,
and thought, if necessary, it should go back, I think.
Yes, indeed.
But in page 41, the issue is approached on the assumption that co-sponsorship is not acceptable.
Yes.
So that's the basis on which that
indeed,
proceeds.
your Lordship is absolutely right. The Court of Appeal says differently. Co-sponsorship, in principle,
yes,
is acceptable. Lords, I should
I'm sorry. I didn't think the Court of Appeal dealt with 3173 at all, did they? In this case,
no.
I mean, they just don't mention it.
Well,
No,
I'm sorry.
Or am I wrong about it? If I'm wrong, I want to
passing
show.
reference. It's difficult to find it because page 1, paragraph 113 in Lord Justice Carnwath, I thought was touching on the point when he says there are two separate questions. First, whether the grandmother was at least mainly financially dependent on one or both potential sponsors. And I thought that was a reference to little 3. But the first, it becomes merged in the other one, and he says the two issues are so closely linked he'd remit them both for redetermination. But that isn't the first issue. That
I think Your Lordship's correct, because following on in that same paragraph, on the first point, the position is less clear. Immigration Judge Bolger decided the point in the appellant's favour. There does not seem to have been any challenge to that position.
Yes.
So the point was certainly not being taken against us
That's right.
in the Court of Appeal that we failed to satisfy sub-rule 3.
Well, it's all rather obscure, but I mean, on the thing was sufficiently doubtful for Lord Justice Carnwath to want to remit it for redetermination if necessary.
And there's nothing in the statement of facts and issues that addresses this, either in the issues or I think in my friend's printed case, and it's not an issue that she has sought to raise, which of course doesn't prevent the court from determining it, and I've given my answers to
as we're still on 3173, and your submission rather now overlaps with Mr. Gill's on the VS and Aruna. And I mean, we saw yesterday what Lord Justice Carnwath said about him, did we not?
We did.
Although very stupidly I've gone, but that's paragraph 109, about this mere cundit and all the rest of it.
Yes.
But the one thing I've searched in vain for is any reference by Lord Justice Laws to the 3173 point.
I didn't find it either.
I'm not aware that there is any.
The only passage I found really was 113 in Lord Justice Carnwath.
Well, indeed.
Exactly.
Indeed.
Exactly.
Indeed. Yeah. I mean, my understanding from those who were there is certainly that this did not form a major part of the argument in the Court of Appeal. The argument was rather focusing, certainly in our case, was focusing exclusively in our case on the question of what's going to happen in this country. Was there going to be adequate, proper finance provided in this country? Is third-party finance satisfactory? Can you have joint sponsorship?
Thank you.
Thank you very much.
Lords, there was one further, of course, factual issue in our case, because the Court of Appeal held that Immigration Judge Bolger's finding that the granddaughter, Ayan, could adequately maintain the appellants in this country could not stand in the absence of further reasoning to support it. And the appellants, we have not sought to appeal against that finding, but Lord Justice Carnwath's approach was that if we were to succeed on the issues of construction, the issues of principle, the appeal ought to be allowed and the case remitted, as Lord Justice Carnwath suggested at paragraphs 111 and 114, for further consideration as to what the proper analysis of the facts are in our cases.
Yes.
As I've already indicated, and my friend Ms. Garsfrisk has accepted this, the two cases, KA and MI, must stand or fall together, as Lord Justice Carnwath has said at paragraph 114. Lords, unless I can seek to assist further, those are the submissions we make in support of the appeal of KA and MI.
Thank you very much indeed. Mr. Ryan, do you wish to follow?
I do not. I don't think I did.
Thank you very much. Now, Ms. Garsfrisk.
My Lords, on the interpretation issue, we make four main points. First is that the immigration rules set out the Secretary of State's policy and are not legislation, so should not be interpreted with the same strictness that would apply to legislation. One shouldn't adopt an unduly legalistic approach, as Lord Justice Laws put it in the Court of Appeal. As the House of Lords decision in Odelola tells us, one should adopt an approach of looking at the ordinary meaning of the words, but, of course, taking into account the rules as a whole and their function in the system of immigration control. Now, I should make it clear that we're not attaching any particular importance to speaking of the intention of the Secretary of State. Of course, we accept that one has to look at the intention as manifested in the rules, what his intention must be taken to have been. Our second main point is that the rules are not required to guarantee human rights convention compliance. And it follows from that, we would say, that there isn't here an interpretative obligation that requires the court to depart from the ordinary meaning of the rules or the meaning that it would otherwise arrive at in order to find a convention-compliant result. As we've seen, convention compliance is ensured through the vehicle of paragraph 2 of the rules. The third main point is that looking then at the words of the rules set in their proper context, neither of the two rules we're concerned with, paragraph 281 and 317, permits third-party support. And fourthly, if we are right that that is how they should be interpreted, that does not make the rules unreasonable or irrational, I should say, or otherwise ultra vires. The exclusion of third-party support reflects, we would say, an entirely legitimate concern to protect the public purse because of the risks that third-party support will be unreliable and the difficulties in verifying such support. So those are our main points, but if I may, I will actually first go straight to the words of the rules we're concerned with and then deal with the other points insofar as necessary later on. So looking first at paragraph 281, the spouse rule, subparagraph 5, as we've seen, and you have it, of course, in Authorities Bundle 1, tab 8 at page 2932. The relevant sub-rule requires that the parties will be able to maintain themselves and any dependents adequately without recourse to public funds.
Can I just be quite clear? You go straight to little 5.
Yes. At the moment, yes, I'd like to go straight to little 5.
Does that tell us anything about your approach to little 4, the accommodation
yes,
provision? What is your position on that one?
Our position on that is that we accept that it is possible that the accommodation will actually be owned by someone else. But we say, nevertheless, the requirement that the accommodation must be owned or occupied exclusively by the parties, by the couple, reinforces the central role of the sponsor in the scheme, which I will come on to, the sponsor, or indeed, in this case, under this rule, the married couple themselves.
So this could be rent-free accommodation.
We don't dispute that that could be so, but nevertheless the focus of subparagraph 4, as I've said, is on the couple themselves in the sense that they have to own or occupy the premises exclusively. But I was going to come back to that point in due course. But homing in, first of all, on subparagraph 5, if I may, we do say that the words "the parties will be able to maintain themselves" have some meaning and are of some considerable importance. As a matter of ordinary language, we would suggest they refer to the couple supporting themselves from their own resources. Most people would surely say that there is a real difference between a person maintaining him or herself or being maintained by someone else. When a wife is maintained by her husband, she's not maintaining herself, or vice versa. And can I just say here, in relation to a point made by Mr. Fordham, that the case law that the court has seen, that has agreed with our submission that these words mean something, in particular KS India on Rule 95, and of course our own AM case on Rule 281, whatever regrets any of the judges may possibly have felt about this, they were, in our submission, entirely right on the ordinary meaning of these words. But I hasten to add that our interpretation does not, of course, mean, as I think Mr. Fordham suggested, that a married couple can never seek assistance from a wealthy relative. There's nothing to stop the married couple from borrowing money from a wealthy relative or indeed friend, because once the money is obtained, is actually received, it does, of course, become part of the couple's own resources. In the same way, we would suggest, as salary from employment will, of course, when it's received, but in addition there, you have the fact that the salary will be received pursuant to a legal obligation to pay it to the employee.
Well, you would include, presumably, also the position of people being self-employed.
Yes.
They can generate money themselves by their own
efforts. They can generate money themselves, and the money will be, on any view, on any realistic view, part of their own resources. Can I say we accept that, of course, there could be, as it were, fact-sensitive issues as to whether funds are part of the party's own resources, or whether, in truth, what is happening is maintenance by someone else. But our point is that the rules properly construed suggest that that line has to be drawn, and that one has to look at, really, whether, as I've said, it is the parties themselves maintaining themselves, or someone else doing it.
So is it, you accept a loan would be all right, is that right?
Once received, my lord.
And a gift?
Once received, again, those funds are, of course, part of the resources of the couple.
So the person says and proves to the officer who's considering the entry, proves that I'm going to get a loan of whatever or a series of loans from somebody. That's good enough?
Well, my lord, that does beg the question, what is meant exactly by I am going to get a loan?
Because well, it's all written down and says he's going to...
No, we would say at that point, no, because unless one can find a legal obligation, something that is enforceable,
right,
then it wouldn't actually count.
You don't actually need to have received the money.
Provided it was legally enforceable.
And that overdraft facility?
Yes, probably, my lord, on the basis that there is an entitlement to it at that time.
I thought banks can retract them, can't they?
Well, of course, employment relationships can also be terminated.
Absolutely.
In certain situations. But we have to be realistic and, of course, accept that, in a sense, nothing lasts forever. All sorts of things can happen. Employment can be terminated, for example. Overdrafts can no doubt be terminated. But the point is, if the couple have something that they can legitimately call an entitlement at the time that can be enforced, then we would say that that would count as being part of their resources. But if all they have is a friend or relative who says, I am happy to pay a monthly allowance to maintain this couple, but it isn't in any sense legally enforceable. And we're not talking a deed of covenant or anything like that. Then, in our submission, it falls on the wrong side of the line.
But the ordinary words which you say we should concentrate on focus on ability to maintain themselves, not legal entitlement to funds. Ability to maintain oneself.
Yes. It's ability to maintain themselves, from their own resources, we would say. So ability, yes, but it's a question of will that be maintaining themselves, ability to maintain themselves.
Well, to take the example of my Lord Roger, let us suppose it is established to the entire satisfaction of the entry clearance officer that a wealthy relative will provide funds on a regular basis into the future. Does that not speak to the ability to maintain themselves from the series of gifts that has been promised?
Well, my Lord, again, we would say unless and until they can actually point to having the funds, i.e. they have already been given, not just promised, or there is a legally enforceable commitment, they cannot use that to say we will be able to maintain ourselves.
Is that the only way of demonstrating ability? That you have the funds in your hand, or that you have a legally enforceable agreement that they will be paid to you?
We would suggest that would indeed be the obvious way of drawing the line, that you have the funds or you have some right to them. And of course, that brings us to the important point about public funds, because public funds, as we have seen from the case of MK Somalia that I think Mr. Fordham drew to your attention about disability living allowance, public funds can indeed be counted as the funds of the applicant or the couple for these purposes. Of course, they will be their funds once they're in their hands, but more than that, there will also be a recognized entitlement to them once you're eligible for them.
But the problem about the entitlement is perhaps thrown into focus by the example of the self-employed individual. I mean, it could be somebody who has skills which can be put to work in providing some kind of service, acting as a hairdresser or something of that kind, which is perfectly well demonstrated because the person has kept up a very good business elsewhere and is coming to this country and says, and indeed convinces the officer that he or she can provide this service here too, but it's one of the features of the self-employed that you can't guarantee your market.
You can't guarantee any more than, as I've said, we would accept you can't guarantee employment. But the point there surely is that the self-employed person has entire control over his situation. And in that sense, whatever is available through his business can count and will count effectively as his resources. You're not dependent on a third party who may easily change his mind.
Well, it's his own efforts, obviously, to
and
produce
under
the money,
control.
but there's no guarantee the money is actually going to come. All you can say is that he's got a particular skill which has a reasonable prospect of producing something.
My Lord, I accept there won't be a guarantee, and of course there will never be a guarantee, as I say, in the sense that employment may end, employers may become bankrupt.
Well, I wanted to press you on employment. I mean, if your formulation, you must have the funds or a right to them, you're working for your uncle.
Yeah, well, if you are employed by your uncle so that you can point to a contract of employment that would entitle you to payment for your work.
But it's not in your control, he can terminate it.
No, I accept that, my Lord, he can. But
So you haven't got the funds and you haven't got a right to them.
Well, you have got a right to them, my Lord.
As long as you continue to be employed.
Absolutely. This scheme...
Why is there a great difference between that and a rich uncle who says, you're dead keen to get your spouse over and I'm keen too. I absolutely guarantee I'll give you this amount of money, etc., etc. on a monthly basis. I mean,
I accept, my lord, that there are contingencies in either situation. Nothing in life is certain, apart from death and taxes and all that. That must be so. But there is a different kind of contingency when you're concerned with a third party who has no underlying legal obligation to pay at all. He may well not have, as it were, any moral or familial obligation either, because he could, on the appellant's interpretation, be anyone, literally. It doesn't have to be a relative at all. And of course I'll come on to this, you have the further factor that the scheme envisages undertakings that can be had from a sponsor, but not, crucially, from the wealthy person in the street who may be a friend, who may write a letter saying, I am happy to keep paying.
but we have to consider these tricky questions. I mean, in the context, as the appellants make repeatedly plain, that you've got to satisfy them that this money will be there. I mean, so you postulate that you can satisfy them. You can satisfy the ECO that this rich uncle is not going to renege on his promise. He is going to maintain it. I mean, but you're saying, terribly sorry, the rule doesn't allow it.
Yes, and we do say that that sort of line drawing is very much a matter for the Secretary of State's policy. It's within his remit and discretion to decide that actually it is simply going to be too difficult and administratively burdensome for the entry clearance officer to seek to grapple with this sort of thing. And in truth, I think it's accepted by the appellants that there are very real difficulties about the entry clearance officer, certainly, grappling with these issues, because he is, of course, not going to have cross-examination of the relevant individuals. He is not going to have the third-party friend in front of him and be able to quiz him. And I think particularly Mr. Gill came close in his submissions to really accepting that if third-party support is allowed, then in effect the entry clearance officer may just have to say, well, sorry, I can't grant leave, because what can I make of this letter that has been written by the third party? Not an awful lot. And that then, in a sense, the balance would shift to the real decision-making taking place within the appellate structure. And in our submission, that in itself is an undesirable result and unlikely, and of course this is the real point, unlikely to be the Secretary of State's policy.
What's the difference between the rich uncle, for this purpose, between the rich uncle who writes a letter saying I'm going to pay so many pounds a week, and the rich uncle who says I'm going to employ the chap in the shop?
The difference is, my lord, that if the person is employed, he has at least then, during his employment, he has an entitlement under his contract to his salary.
Well, that's just begging the question. At the point where the officer is considering whether the party is able to maintain themselves, what is the difference between an offer of periodical payments and an offer of a job?
Well, my lord, the difference would be that if the entry clearance officer accepts that the offer will be made and will be genuine, you have at least that certainty that I've described, that there's a legal right to it. If you have simply an offer that in the future I will pay, I accept that in both cases we're assuming now that, as it were, the offer hasn't yet materialized. It's something that will happen in the future. But you have the further contingency, if it's simply an offer to pay money, that there is no, as it were, inherent basis for that to keep on being paid.
Well, the shop could be closed.
As I said, my lord, I accept that employment may not last forever, but if we're talking about drawing a sensible line, which I would suggest most ordinary people would probably understand, between is this person maintaining himself or is he being maintained by someone else, then that is where the line really would have to be drawn. I couldn't possibly suggest that a person's salary could not be taken into account as part of their resources. I wouldn't dream of that, of course. But there is a real difference between that and, say, Mr. Arunan, however much he may have, in a sense, proved his worth in the case of VS by actually paying. There is a real difference between employment and someone like that who says out of the goodness of his heart, I'll do it. But what happens if he then gets other family commitments, which may cause him to change his mind, or indeed the offer may never have been genuine. Now, then it's said against me, well, that can all be decided on the evidence. But then we come back to my point about the scheme envisaging that the entry clearance officer should be able to actually grapple with these things.
Well, why, if that is the Secretary of State's policy, and you say it is, in the connection with this rule, doesn't the rule make it clear in the way it does in 263, where the words "from his own resources and with no assistance from any other person" is set out in the plainest terms? That would make it absolutely clear. The officer would know that it's no use referring to the rich uncle. You've got to look at the resources of the individual himself. And there it is. And one can see on the face of the rule exactly what the point is. And aren't we entitled to look at the rules and cross-refer to other rules and put it in these terms and say, well, that's very interesting. There that is set out there. In this case, we don't have that qualification, and therefore one can look more broadly at the sources of income, whatever they happen to be.
One answer, my lord, is probably that no one would win a draftsmanship prize for the way these rules are formulated. I would accept that, and I hope no one behind me would mind. This is where it's important not to adopt that unduly legalistic approach.
It's not really particularly legalistic. It's just reading the chapter as a whole and saying, well, to oneself, well, if you want to make an exclusion, and it's done obviously in the case of public funds, but if you want to say that something is not relevant, then you simply say so, and everybody understands where they are.
That's one answer. The not unduly legalistic approach is one answer. The other answer is that within the scheme of the family rules that we're concerned with in Part 8 of the rules, because, not least because of the crucial role of the sponsor that I'll come on to, in our submission it is clear in any event, and I'm looking now both at 281 and 317, that it cannot be envisaged that someone other than the sponsor under 317 or the couple itself under 281 should be able to maintain. So there's a different scheme where there isn't the same need to make clear that you can't have resort to third-party finance. In any event, of course, as I started off saying, if we look at Rule 281, 2815, then the words do bear a meaning that clearly indicates the intent that we are arguing for by referring to the parties maintaining themselves.
What's the point of adding without recourse to public funds?
There's a very important point in that, which is that public funds, as we have seen from MK Somalia, not least, can be counted as the couple's own resources. They can be seen as their monies. And so it's important to make it clear that when one says they should maintain themselves from their own resources.
Well, assuming it did say that, yes.
Yeah, they mustn't, yes, on our interpretation. They nevertheless must not resort to public funds in the way that is then further elaborated on through paragraph 6A. 6A, my lord will recall, says it's about relying on additional funds. So,
sorry, but if you didn't have those words, just explain to me how it would be any different in operation?
If you didn't have those words, the couple might say, well, all that's required is that we maintain ourselves from our own resources, that's if we're right.
Yes.
Our own resources include public funds to which we're entitled. Therefore, there's absolutely no problem about us relying on public funds. What the second half of the rule then does is to make it clear that there is a problem about relying on public funds.
But only insofar as there are going to be more public funds, and that would
Yes.
be so anyway.
Well, no, my lord, not necessarily, because any additional public funds could still be part of the couple's own resources. So they might say, well, that's all fine. My partner in the United Kingdom will be able to claim some more public funds. That's all right. That all is part of our own resources. So we satisfy the requirement of maintaining ourselves. What's the problem with that? Now, that phrase, without recourse to public funds, is then added in to make clear that that doesn't work. So it does have a role to play. We set that out in paragraph 31.2 of our printed case in AM number 2. I'm not suggesting, my lords, that that adds anything to what I just said. It's just that you have a reference to how we put it in writing. So that's our case in AM number 2.
Yeah.
So turning
So
then...
do I understand that your position is that public funds would not themselves be third party? The money you receive from the government would not be money you were receiving from a third party?
Yes, it could count and would ordinarily count as the party's own resources, something they're entitled to, ex hypothesi, and that's why you have, as I say, that second half of the rule making it clear that nevertheless they can't rely on such funds, certainly not additional such funds. That's explained further by paragraph 6a.
Well, I think we may have talked that particular point out. Is that right? Is there anything more you'd like to say on
No, my lord,
construction?
I was going to move on to the role of the sponsor
Yes.
then. The sponsor is, of course, the person that the applicant for entry clearance is seeking to join. That is made absolutely clear from paragraph 6 of the rules that defines the word sponsor. So I don't think it's really disputed anymore, but the sponsor couldn't be a charity for these purposes. I think that was mooted in argument during Lord Panic's.
The old version of the rule rather suggests it might have been, but it's been rewritten to make it absolutely clear it's an individual, I think.
Yes,
Yes.
that's right. That's what one gets from paragraph 6.
When was the definition added? I mean, has there always been a definition of sponsor? I mean, has 35 always been there in some form, and 6, the definition 6, has it always been
My
there?
lord, that I would have to check. I believe it is a scheme of considerable antiquity.
I suspect the word sponsor suggests it probably is very old.
But I will need to come back to your lordship on that. We'll make a note of that. Now, because the reason, the particular reason that the sponsor is so central to the scheme is that it is from him or her, and only from him or her, that the Secretary of State can obtain an undertaking under paragraph 35 of the rules. And it's perhaps worth looking again briefly at the words in paragraph 35, which you have on page 2805 in tab 8 of bundle 1. Of course, that rule refers to a sponsor giving an undertaking in writing to be responsible for that person's maintenance and accommodation. And you then have reference to the possibility of actually recovering monies from the sponsor where state funds have been paid out. And if you just look at the second paragraph, which deals with support for asylum seekers, but again focusing on the undertaking that can be had from the sponsor, about halfway down the second paragraph, it says failure by the sponsor to maintain that person, it should be in accordance with the undertaking. So here you have the phrase failure to maintain that person, suggesting in our submission that you are here concerned with an undertaking actually to maintain the applicant for entry clearance. It's not, as it were, simply a guarantee to step in if someone else fails to maintain. And if I could just briefly also complete that submission by referring you to a couple of provisions in the Social Security Administration Act 1992, which of course is mentioned in both subparagraphs of paragraph 35, where they deal with this possibility of recovering monies from the sponsor. Now, those should have been handed up to your lordships. I hope you have a little clip from Halsbury's statutes.
Yes. We've got two clips, I think, from Halsbury.
One should begin with the 1992 Act. That should be the second page of the cover page.
Yes.
That's the one for present purposes. And if we go first to section 105, which is actually...
I'm terribly sorry. I'm just not...
I think it looks like that. It's and it's the fourth edition, volume 41, 40 brackets 1 reissue.
That's right, my lord.
Did it come this morning, did it?
Yes, there was a bunch of about 4 things that came this morning.
It's entirely my fault. Just carry on, please. I'll find them. Just carry on.
I think one of the things you lifted us just now did come this morning.
Yes,
It's got a treasury.
I'm
Here we are.
very sorry,
I've got it. It's okay.
Thank you.
The right one.
So, section 105 then creates an offence one sees at subsection 1.
Yes.
If any person persistently refuses or neglects to maintain himself or any person whom he is liable to maintain, and in consequence of his refusal or neglect, income support, an income-based job seeker's allowance, or an income-related employment and support allowance is paid to or in respect of him or such a person, he shall be guilty of an offence. And then at subsection 3, subject to subsection 4, for the purposes of this part, a person shall be liable to maintain another person if that other person is A, his or her spouse or civil partner, or B, a person whom he or she would be liable to maintain if sections 7, 8, 6c and 9 had effect for the purposes of this part. So you then go to the beginning of this clip, which has section 78, headed Recovery of Social Fund Awards. At subsection 1, it says a social fund award which is repayable shall be recoverable by the Secretary of State. And then the key part, subsection 6, for the purposes of this section, and one goes to C, a person shall be liable to maintain another person throughout any period in respect of which the first mentioned person has, on or after 23rd of May 1980, and either alone or jointly with a further person, given an undertaking in writing in pursuance of immigration rules within the meaning of the 1971 Act to be responsible for the maintenance and accommodation of the other person.
But, I mean, this can only apply if it's needed. I mean, the contingency which is envisaged is that they're not getting anything from the sponsor and the person has become a liability on the state and the state has had to pay benefits. If the person is working, I mean, the obligation to maintain doesn't mean that you've got to maintain irrespective of whether or not the person is maintaining himself.
Well, if you're looking at a couple under Rule 2815, then of course the idea is that they have to be self-sufficient, and in a sense, it doesn't much matter who or which one of them. But if you look at 317, then that rule, of course, and we'll come on to the detail of that, but that envisages long-term dependence, financial dependence on the sponsor, so that one would be very likely, certainly there, to have actual payment by the sponsor.
An 18-year-old son or daughter comes over, gets a job.
Well, the 18-year-old son or daughter, one knows under 317, for them to come over and join a sponsor, there would have to be exceptional compassionate circumstances.
Yeah, got to assume all these other things.
And there has to be existing dependence. So all I'm suggesting is that it's quite likely that there will actually be ongoing dependence there as well.
It's a very depressing view to take of the world. I mean, they come over and actually gets a job and gets on with life. I mean, that's what we hope happens. I mean, and if they do, then there's no requirement. This is you're liable to maintain. It doesn't mean that you have to maintain. You're not obliged to maintain if the other person's maintaining. It's a sort of fallback position to make absolutely certain that if they land up on the state, then the state can get the money from the sponsor. Because the sponsor should have been maintaining them if they are not maintaining themselves.
My lord, it's true, there is a liability to maintain. It may be that if in practice the person who has come to this country has a job and all is fine, there's no need for the sponsor to actually put his hand in his pockets. But for our purposes, what's important is that there is that liability to maintain, and if things go wrong, then, well, before things go wrong, there's the ability to get the undertaking, and if things go wrong, the ability to enforce it.
Well, presumably the immigration officer can take a view about this, looking at the first sentence of paragraph 35, Rule 35. The request is made, I think, of a person who's seeking to leave to enter, so that's the stage one's contemplating. But if it's absolutely clear that there's a rich uncle whose ability to either offer employment or provide funds is unquestioned, then you wouldn't need to resort to this, would you?
Well, of course, here we're assuming then that the rich uncle is the sponsor.
No, I'm not doing that. I'm assuming that behind the individual there's the first rank, as it were.
But then, of course, there wouldn't be an ability to get an undertaking from the uncle under paragraph 35.
That's right, but you wouldn't need to if the officer was satisfied there was no reason to doubt his ability to stand by the individual and do what he said he was going to do.
If that were really so, but what we really derive from this is that it's inherently unlikely that if you have a system, as you do, that has certain safeguards, i.e. the possibility of getting an undertaking from a sponsor where there are doubts about the ability to maintain, and an enforcement machinery that goes with that, you have that for the sponsor. It is inherently unlikely that if the Secretary of State's policy really was to allow maintenance by someone quite extraneous, a third party, it's unlikely that there wouldn't be some protective machinery in relation to such a person. Granted that maybe there could be a situation where the evidence was so overwhelming that there wasn't any real concern about the third party. But if we're looking to find out the Secretary of State's policy, we ask rhetorically, does it make any sense to have this enforcement machinery, the possibility of an undertaking in relation to the sponsor, but not in relation to someone whose promise, almost by definition, will be less reliable? That's not said with any disrespect to kind friends or relatives, but it is simply a fact of life that will be so.
Well, the submission would have been much more weighty if Rule 35 was worded in peremptory terms, but it's quite clear it's something that is available to be used if thought to be appropriate. It just simply may be asked. So that assumes or indicates that it wouldn't be needed in every case. And therefore there's a question of judgment as to whether you need to have this undertaking or not, and that would depend on the circumstances.
That of course is so, but one still is left with the question, I would suggest, why on earth should that possibility of getting an undertaking not even be there for a third-party supporter? Why should there be, in some ways, this gaping hole where, on the appellant's case, third-party support is perfectly possible, but there is just no enforcement machinery in relation to such a person, although there is one in relation to the sponsor? That does not, in our submission, make any sense.
Could you help me with why you extended the definition, why the Secretary of State extended the definition of sponsor to 317, for example, and so on? I mean, why was that done, which then narrowed the range of people, didn't it? Who
Why
could be
did he
sponsored.
extend
Yes,
it
why
as-
did he? Well, I mean, you've got a definition which he then extended, and it's in one sense a narrowing definition. That's your point. I mean, you're saying you can't be a sponsor.
I'm so sorry, my lord. Entirely my fault. Extended in
Yes,
what sense?
if you look at the definition in 6.
Yeah.
As I understand it, the case which we looked at earlier, whatever it was called, at that stage the definition stopped. It said 277 to 295. And it's now been extended to 317 to 319.
Yeah.
I'm not sure how that may happen.
In the GG case,
Yeah.
the old definition of
Yeah,
sponsor was
didn't-
referred to. That's what I was thinking of.
Yeah.
And then now it adds those words through it,
Yeah.
even though I can't say why.
Well, my lord, one obvious reason is precisely to enable an undertaking to be had from the person that the relative from abroad is seeking to join.
When it wasn't defined out, when it wasn't narrowed in that way, as I understand it, the case we looked at earlier was interpreting sponsor, said, but since it hasn't got a narrow definition, it's not defined in that way in these other rules as it then was 317, that's why they were able to interpret it widely. We saw charities or so on discussed as being possible sponsors. And I suppose under that system, you might have said the rich uncle or the rich chap who was going to provide money could have been a sponsor. But you've narrowed it. And what I want to know is, why have you narrowed it?
Well, my lord, certainly one answer is that it properly reflects what that rule is all about, which I'll come on to, but 317 being about a particular kind of family unit where you might not only do you have to have prior dependency, but you then have, certainly on our submission, future dependency on the sponsor, and you have a family unit where support is expected not only at the beginning of the process but for the future, and that the changes were made to reflect that reality and that intent behind the rule.
Was the word sponsor in the predecessor of the current 317 little Roman 4? I ask the question because it looks from the footnotes as though that new paragraph was substituted by the same, so they were substituted by different routes, weren't they? It was Command 4851 substituted the new subparagraph, and the definition was amended by HC 582.
Yeah.
So it's difficult to keep track of exactly when these various things were going on, but were they simultaneous or?
I believe that 582, my lord, was later. I believe that was in 2003.
Right.
And 4851,
Yes.
I believe, is the one that came in September 2000.
2000, right. So we had sponsor in before the definition was amended.
Yeah. My Lords, can I just also make one point as to the importance of undertakings in the scheme as a whole?
Yes.
Just this additional point, that in determining eligibility for welfare benefits, it's important whether you are subject to immigration control. And you will be held to be subject to immigration control if you have been given leave on the basis of an undertaking under the immigration rules. That, without going into huge detail, one gets clearly set out in a case called Ali Ahmed, which I hope has also found its way to your Lordships. That's the Court of Appeal.
Yes.
And the issue in that case was whether something that had been given by way of declaration was actually an undertaking for the purposes of paragraph 35 of the rules. And neatly summarised what I was trying to say a moment ago, paragraphs 7 to 12, that they actually set out this point. So this is Lord Justice Wicks. Paragraph 7. It's also necessary to refer to section 115 of the 1999 Act, which provides in effect that if that section applies to a person and that person is excluded from various welfare payments, such as an income-based job seeker's allowance and of particular relevance to this appeal, income support. Then subsection 3, this section applies to a person subject to immigration control unless he falls within such category of description or satisfies such conditions as may be prescribed. And then section 1159 refers to a person subject to immigration control means a person who is not a national of an EA state and who has leave to enter or remain in the UK given as a result of a maintenance undertaking. And that concept is then defined in subsection 10, means a written undertaking given by another person in pursuance of the immigration rules to be responsible for that person's maintenance and accommodation. It's clear, therefore, from these statutory provisions to which I referred, that there's a link between the terms upon which dependent relatives may be admitted to this country in circumstances where their relatives here provide a written undertaking to be responsible for them and provisions of the Social Security Administration regime.
Well, so in circumstances where that is done, there clearly is a link, but it doesn't follow that there has to be that link in every case.
I entirely accept that there will not be an undertaking in every case, so this was simply to add further support to the point that undertakings, and therefore also the role of sponsors, is something that is important under this scheme, albeit I accept that there will not always be an undertaking in fact.
That's paragraph 12, really.
Yeah. And of course, your Lordships have seen paragraphs 320 and 322 of the rules, at least I think Lord Panic took you to paragraph 320, which provide that leave should normally be refused if someone has been asked to give an undertaking and they don't then give it. And again, although of course I accept that it isn't mandatory to refuse leave in such circumstances, it is nevertheless another pointer to the importance of undertakings and therefore the role of the sponsor.
Yes.
Looking further at paragraph 281, just very briefly, paragraph 2814 again, the rule that requires accommodation to be provided by the sponsor, that is to say, in accommodation which they, well, the couple in this case, own or occupy exclusively. I've really, I think, made the point. We say, yes, it's possible for a third party to own the house, it's possible, But nevertheless, this rule actually reinforces the important role of the sponsor, because he or the couple must own or occupy the premises exclusively. So it reinforces the family unit that this particular rule is all about.
But they can be doing so entirely rent-free and entirely by the generosity of a relation or indeed just a friend.
They can, my lord.
Or it could be that there's a substantial rent to pay, but there is a gift coming every month to make sure that the payment is made.
My lord, I accept that to that extent support from another person can come in under that rule. But it doesn't by any means follow in our submission that the Secretary of State may not have a policy that says, all right, if a third party provides the accommodation, that's one thing, but actual maintenance has to come from the couple itself or the sponsor.
I mean, I'm not quite clear why you accept that the third, somebody can generously give monthly rent. Why isn't that all part of the maintenance?
Well, my lord, maybe there could be arguments about that, but as I understand it, the practice has certainly been to accept that if accommodation is there and occupied exclusively by
Whoever
couple
pays,
in this case, then
whoever pays for it, and on whatever basis, that's all right.
now another point or another indicator, we do say that the words maintain themselves really do mean maintain from their own resources in 2815, is this point that serves to give concrete effect, as Lord Justice Laws put it, to the family unit. That's Lord Justice Laws at paragraph 56 of the judgment in this case. Now, of course, Mr. Fordham says, oh no, this rule, if we are right, will serve the opposite purpose because it may prevent people from being together in this family unit. But that, with respect, we would say really misses the point that we're talking about giving effect to the unit through requiring the unit to behave in the sort of mutually supportive way that one would expect of a family unit, if you will. So, therefore, the parties supporting each other, supporting themselves in the marriage, or under 317, the sponsor supporting the incoming relative. In fact, that's really what the House of Lords had in mind, we would suggest, in Bioku Betts that Mr. Fordham has cited, where there was a reference to the ability of family members to be able to rely on others. Well, that's precisely what this rule really contemplates here in a financial sense.
Well, one bears in mind, I suppose, little 3 in Rule 281, because the Immigration Office got to be satisfied that this is a relationship where the parties intend to live permanently with each other, and the marriage or civil partnership is subsisting. So, I mean, from that point of view, yes, one can see that the family relationship is very important. Then one goes through the hoops and the other places, just to see that there's the accommodation that's needed so that they can actually live together.
Yes.
And it's not very important, you accept, as to where the resources come from that, provided they own or occupy the premises exclusively. And then one's got the maintenance themselves. And we come back to the same point, really, the absence of any apparent, any express qualification excluding third-party support there.
Well, save for the fact that you do have the important words, maintain themselves. And, of course, added in, as I said, the central role of the sponsor. Now, apart from this notion of giving effect to the family unit in a particular way, i.e. in a financial way, of course you have our key point, about the reliability, or rather potential lack of reliability of third-party support. And we have given some quotations from the case law in paragraph 58.6 of our printed case.
Which printed case are we looking at?
This is AM1.
AM1.
Yeah. You're very familiar with what Lord Justice Tuckey said.
Sorry, which paragraph is that?
That's 58.6 in the printed case in AM1.
Yes.
So you have the reference to Lord Justice Tuckey's comment in MW Liberia, first of all, necessarily more precarious and more difficult to verify. And then also Lord Justice Elias, this time in AM number 2, where he refers to the same comment, what Lord Justice Tuckey referred to as the precariousness of such funding and the difficulty of ensuring it's genuine, in my view, justifies the refusal to draw this distinction. This is now dealing with the distinction for disabled persons that Mr. Forden will argue about tomorrow. By definition, the third party will not have transferred resources to the applicant or his or her spouse. There's still a very real risk that state funds will be required to maintain such persons, and potentially significant administrative costs will be involved in testing the reliability of third-party promises. So there's also that important point about administrative resources, the difficulties that I mentioned for the ECO in grappling with this kind of issue. My Lords, turning then to paragraph 317, if I may. Here we say that taking the rule as a whole, and of course also in the context of the other relevant rules, third-party support is excluded both as a feature of prior dependency and looking at future maintenance. And in paragraph 60 of our printed case in AM1, we have set out the different subparagraphs of the rule and made some comments about those. And it may be worth taking a little bit of time over that. So that's paragraph 60.
Yes.
First of all, the introduction to paragraph 317. The requirements to be met by a person seeking indefinite leave, etc., as the parent, grandparent, or other dependent relative of a person present and settled in the UK. So, first indication of the need for pre-existing dependency on a person settled here. Then, in our submission, very importantly, at 1D, you have the reference to how a parent or grandparent over 65 can come in. Here, we're looking at persons who have entered into a second marriage or civil partnership. And I quote, but cannot look to the spouse, civil partner, or children of that second relationship for financial support, and where the person settled in the UK is able and willing to maintain the parent or grandparent. Now, this is a subparagraph that I don't believe any of the appellants have yet dealt with. It is, we would say, a very clear indicator that in relation to this category of potential entrant, support is to be provided, or maintenance is to be provided, by the person settled in the UK. That is what the rule is expressly looking for here. And
but
that, of course,
it's only,
yes.
we can see it, obviously, it's obviously plain that it applies to D, but A and B and C are not qualified in that way.
No, that's right, my Lord, but it does then raise the question, can it really be the case that the Secretary of State intends that this particular category, elderly parents or grandparents who've entered into a second marriage, that they would alone be confined to to looking to the sponsor in the UK for maintenance, i.e. the relative they're seeking to join, where persons in other subcategories would not be so confined. And we would respectfully suggest that there can't be an intention to draw that distinction, which would appear to be wholly arbitrary. So it is a strong indicator.
Why do you say it's wholly arbitrary? This is an additional qualification on branch D. It's a rather unusual situation where there's been a second relationship of marriage or civil partnership, but the partner to that relationship can't be relied on to provide financial support, and you've then got this additional linkage that is necessary in that particular category. Now, the fact that it's there rather suggests that you wouldn't be getting the same requirement out of the other bits in the rule.
Well, yes, well, that might be so if one could perceive any reason, any sensible reason why persons in this category should, as I said, be confined to looking to the sponsor for future support. I mean, in each category, you are assuming a person who has no one else to rely on, who doesn't have other relatives to rely on. You're assuming that they're already dependent on the sponsor, and we'll come on to subparagraph 3 in a moment. Here, you then have that express reference to looking to the sponsor for future support. And I would respectfully say it's impossible to see why it should be so for those who have married for a second time and others who can come in under any of the sub-paragraphs in this rule. Why? What is it about people who've entered into a second marriage?
Well, part of the thing is that, they're going to land themselves on the child of the first marriage, and one of the things they've got to be satisfied about is, for example, the child of the first marriage is going to take on the new spouse and any children who are coming along with them, and that might be more than an undertaking. And I don't actually see that it's any different here, really. I mean, the question is, are they able and willing? Now, they may be able and willing because their friend or somebody else is going to give them the money with which to finance this new lot of arrivals. I mean, it's just exactly the same thing.
Well, my lord, whether or not they could rely on someone else, whether or not the sponsor could rely on someone else providing the money, that of course raises, if I may say so, the different point as to what do we really mean by someone actually maintaining. I mean, this rule envisages that the sponsor, the person settled in the UK, is able and willing to maintain the parent or grandparent. We say that means that that sponsor must maintain from his or her own resources.
You say that, but I mean, it's exactly the same point all over again.
But it's the same point as 281. I mean, is your submission that this, so to speak, you've got a stronger argument here under 3171D than 281, or that they're the same? And is this to combat an argument that 317 is actually more difficult from your point of view?
It is to combat that argument in the sense that, of course, what the appellants say is that if you look at subparagraph 4A,
right,
that phrase simply says can and will be maintained adequately. So They say that can be by anyone. We say by response, hold on, certainly at subparagraph 1D, it cannot be by anyone at all, on any view, it must be by the sponsor. That's why what that paragraph envisages.
So that's the same argument as 281.
Yes. But yes. And it's really used, as I say, to respond to the argument, well, it's as simple as this. 41A says nothing about who should doing the maintaining. 1D does say something about that. And the question then is, well, doesn't that same notion that the maintaining should be done by the person present and settled in the UK, doesn't that same notion inevitably actually apply to the other subcategories? And as I am now leaving to one side my Lord Rogers' point about what do we mean by maintaining? Could the money come from someone else anyhow? So I'm just trying to get over the hurdle of showing that this rule contemplates maintenance by the sponsor. And I'm saying, yes, it does. 1D is a very strong indicator to that effect. Now, why should it be that someone in category 1A or B or C, why should the same not apply to them? It is, with great respect, impossible to find any reason for that. Now, I would therefore say what we have is, yes, a rule that no doubt isn't as well drafted as it could be, but one where, doing the best one can, one gets a very clear indicator from subparagraph 1D.
So you're really saying, in effect, that the rider, the second part in little d after the semicolon,
Yes.
is something which should be understood as common to all of these categories. It's implicit in the other ones, but it needs to be stated expressly in D because of their rather unusual relationship. Is that what it comes to?
My Lord, quite why it was perceived for it to be necessary to state it expressly there and not elsewhere is not immediately apparent, but it is there. It gives an indication in our submission of what must be right for the whole of the scheme here. Otherwise, one would arrive in our submission at an arbitrary result.
If you satisfy D, 1D, if you get, is there any role for 4A at that stage? Or is that?
Well, my Lord, 4A again can have the role that, although little d already tells you.
I'm asking, yes.
Yeah, maintenance from the sponsor, 4A, adds to that there mustn't be recourse to public funds. So it's the point I sought to make earlier, that otherwise the sponsor might say, oh, well, that's all right, I can do the maintaining of the remarried couple from my welfare benefits, because they're still my own, I can do with them as I wish. And the answer is you then look at 4A, and 4A tells you not so. So 4A does have a role to play there too, and has a role in that sense in relation to each of the subcategories. But the point is the maintaining must be by the sponsor, and for reasons I won't go over again, we say maintaining by the sponsor, of course, means by the sponsor, not by someone who makes an unenforceable promise to pay to the sponsor.
I mean, if the person, if the if you call them the sponsor, if the sponsor is on state funds, is receiving benefit, yes?
Yeah.
I mean, does it matter? I mean, the question is whether it's going to be any more benefit
Yes.
has to be paid. I mean,
Yes.
it's not excluded, is it? I mean, I'm just trying to understand.
Well, the question is, under paragraph 6A, the question is whether there are going to be additional state benefits. They can't be used. But in the absence of the express statement that public funds can't be used, and that must then, of course, be read with 6A, the sponsor could be forgiven for thinking, oh, it doesn't matter if I have to get, or I do get additional state benefits.
So that's the part you
Yeah.
It's additional.
I can use any benefits I get, including additional ones, and there's no problem with that. 4A tells you that there is a problem. And subparagraph 3, of course, is that key provision that establishes that there must be existing financial dependency on the sponsor, wholly or mainly, it says, but in our submission, the fact that it says wholly or mainly is not in any way inconsistent with the idea that for the future, the maintenance must then come from the sponsor.
Wholly.
Yeah. wholly, really for practical reasons, trying to, as it were, control or have some control over this notion of who is going to provide maintenance, how is it going to be provided, etc. It focuses on the sponsor doing it for the future. Accommodation in subparagraph 4, I don't think I can add anything to what I've already said about that. Subparagraph 5, again, is important because where it refers to the person having no other close relatives in his own country to whom he could turn for financial support, we say that sets up a comparison with the sponsor in the United Kingdom. So you compare the person here that he's already dependent on with other relatives abroad. You look at whether there are other close relatives who might support. So again, an indication that the scheme is you're already dependent on someone here, you don't have any other relative abroad who can support you. If you come to the UK in the future, the person you're already dependent on will support you and no one else.
In other words, it implies that you're going to turn to the relative in this country for the support. That's what you're taking, is that right?
Yeah.
Because it's no other relative.
Yeah, exactly.
Yes. Well, that's the analysis in paragraph 60.
Yes.
Yeah.
Yes, indeed, my lord. And in addition, of course, under this rule too, as under 281, you have all the points about the importance of the sponsor, undertakings, and all the rest of it. Now, so far as the case of VS is concerned, just picking up the point about subparagraph 3, of course, in VS, we know that there was a problem for VS about not satisfying 3173 either, quite apart from 4A. Mr. Gill, as I understood him, submitted that 4A means that there can be maintenance from anyone, any third party. That then had to be fed back into subparagraph 3, because those two, he said, should be consistent, and therefore, if you can have third-party support under 4A, you can also have it under 3. But of course, we would say it works entirely the other way around. Subparagraph 3 is very clear that the dependency must be on the sponsor, and that then feeds into 4A, quite apart from all the other reasons that we've given, my lord. And, of course, if we are right about paragraph 281 on spouses, then we also have the point made by Lord Justice Pill in the Court of Appeal that it's inherently unlikely that the Secretary of State would have very different regimes under different rules that all deal with families in Part 8 in the rules. So if 281 restricts maintenance to the couple, then one would expect the same to apply in terms of maintenance by the sponsor under 317. Now, what then about paragraph 2975, which of course isn't directly an issue, but it has been looked at by the appellants? Briefly, and of course I'm looking at the amended subparagraph 5 on page 2946. In our submission, where the rule speaks of a child, of how a child should be maintained by the parent or parents, it means just that. It doesn't simply refer to some parental responsibility, as I think Mr. Fordham suggested. It envisages actual maintenance by the parent. That would be the natural meaning, and a different meaning we would suggest would be contrived. Now, it's been stressed that this rule was amended for child protection reasons, and certainly I would accept that that was a reason, it would appear, for it being amended. Not, however, the only reason, as is apparent from the case of AA Bangladesh. If I can just briefly invite you to go back to that, it's Bundle 6, tab 54. That was, of course, the case where the tribunal considered the amended Rule 2975.
Sorry,
yes.
What's this case?
This is AA Bangladesh
Yes,
at tab 54. And at paragraph 29, the tribunal referred to Amal Ali, and they say the rules then changed after Amal Ali had been decided. Counsel for the ECO informed us that he'd been instructed that the immigration rules had been reconsidered once the Human Rights Act came into force. Third-party support had been relied on too frequently previously in this type of case. Evidence of such support was often not presented to entry clearance officers, and it couldn't be checked. It was said to be a question of child protection that money to support a child should come from the sponsor/parent, who had to provide evidence to the ECO of the position to ensure checks could be made in the UK as the application was being considered. So the point we make is that child protection, yes, but that does not appear to have been the only concern. Certainly this concern about reliability of third-party support was also there. And one may perhaps question whether if Mr. Fordham is right, as I understood his submission, that the money doesn't actually have to come from the parent, one may perhaps question whether that would then really deal with the child protection issue that had been of concern, because if the money actually comes from someone else, a third party, you have that potentially very important role and control, potentially by a third party, over the child, which seemed to have been part of the concern.
When they were busy doing their human rights audit, what was the point? What was the problem about the old four?
One problem appears to have been, as described in paragraph 29 of this case, AA Bangladesh. One problem was a concern about child protection, that if third parties could provide the money to support the child, then there could be a problem about whether the child would be sufficiently protected if it wasn't actually a parent that had to support the child. That's how I understand the concern.
Which of the articles was that?
I'm sorry.
Which article was that?
I don't think that was any particular article, my lord. That was simply a general concern about the operation of this rule, as I understand it. And then in addition, you have the concern about reliability of
that doesn't sound like human rights.
No, my lord. No, indeed. I don't think it actually was about human rights.
Sorry?
My lord, no, I don't understand it was actually about human rights.
No, it came in. It was one of these. It was made on the. It was made on in September 2000, 20th of September 2000.
Yes.
And so, but it may have been coincidental. I mean, that was obviously a human rights tidying up. But
yes,
it may. Are you saying it may just be that they were taking the opportunity of that to make a change for some other reason?
Yes, precisely, my lord.
I wonder if that is what is being said in paragraph 29. Surely the nexus is between the child protection and the checks. The checks are being carried out in order to ensure that there's child protection.
Well, my lord, it may be that the checks were being carried out, as it were, generally because of the advent of the Human Rights Act, and then this child protection issue came up. To what extent that was linked to concerns about human rights, I can't tell your lordship, but it isn't apparent, so far as I'm aware, that there really was that link. But certainly the audit of the rules more generally was linked to the Human Rights Act.
Am I right that the old formulation of little 4 is what is set out in page 6, at the end of paragraph 20? This is off the tab 54.
Yes, I believe that's
so
right.
It built both accommodation and maintenance into a single rule.
Yes.
And it put without recourse to public funds rather further forward in the formulation of the rule. And then it said accommodation which the parents or a relative own or occupy exclusively.
Yes.
So it wasn't as obvious you would accept from that rule that the point you're making now was in the mind of the Secretary of State.
Yes, my lord. Yes.
It's set out in Arm and Alley at page 97, which is the old version.
Right, yes.
Well, the old version of 4 is set out in Arm and Alley at page
Yes.
97.
And that tab is
Tab 53.
53.
Now, one then has the rule that applies to adopted children wanting to join their parents, which is paragraph 310. It may be worth just spending a moment looking at that rule. It's page 2953.
Sorry, I've lost where you're going to.
I was making out, sorry, it's Rule 310 of the immigration rules
Yes.
at page 2953. I'm sorry, my lord.
Yes, thank you.
Now, that's a rule that certainly Mr. Gill fastened on in his written case, although I'm not sure he really mentioned it in his oral submissions. But looking at subparagraph 4, and this, of course, is a rule that refers to adopted children joining a parent or parents. And at little 4, one sees it says, can and will be accommodated and maintained adequately without recourse to public funds in accommodation which the adoptive parent or parents own or occupy exclusively. Now,
Well, that's pretty well the old formulation of the old form.
it is the old formulation, and all we say about that is, again, yes, this has not been amended to make it as clear as 2975 does, that it is the parent or parents who must maintain, but surely, again, the intention must be the same for adopted parents. It's another instance where it is impossible to see any sensible reason why adopted children should be treated differently. Now that then would mean...
It's very
It's
good.
extraordinary.
It's the same command 4851 which is making the change here as it was for the other one.
Exactly.
Very strange.
Now that would suggest that you must sensibly interpret 310 consistently with 297, notwithstanding that 310 uses that language that is much closer to the language in 3174A. So Mr. Gill, I think, would say, oh, well, 3110.5 means what it says. It doesn't specify the maintenance must be by a parent, and that supports his similar construction of 317. But we say no. Again, you must look at this broadly, trying to make sense of it as best you can, and doing that one sees that one cannot pay too much attention to whether a sub-rule spells out or does not spell out exactly where the maintenance is to come from.
It's a bit bizarre, though, isn't it, that in the, what's the Liberian case, MW case, I mean, there it is, the whole thing sort of starts on the basis that the change to 297 was critical. Before that, of course, you could rely on third-party support, but not after. And then the whole thing builds up to a point where then you're saying, oh, well, having reached that view, everything else comes in its way.
Although not only because of that, of course, it is, as I've sought to make out, looking at various other features of the rules.
It's true to say that Lord Justice Laws wasn't at all sure that Lord Justice Tuckey had been right to think that under the old 297 it was any different.
Indeed. And that, of course, would be our position too. And I will come on to the Immigration Directorate's instructions in a moment. I know there are all sorts of objections to us looking at those, but I hope nevertheless that your lordships will be prepared to see them at least.
See what you would have liked to have said if you'd said it.
Ah, no, my lord, to see what the Secretary of State's consistent practice consists of, entirely consistent with what we say the rules say. And in fact, can I go straight to that? The way it comes in is that the appellants say, particularly Mr. Gill, I think, oh, well, there was a regular practice that third-party support was permitted. Now, leaving to one side to what extent it's admissible or relevant to look at regular practice for the purposes of interpreting these rules, that's what the appellants say. We say, by way of response, although we completely accept that we are concerned with interpreting the rules, we say we're entitled to show, by way of response, that the instructions evidence a practice by the Secretary of State, at any rate, that is entirely consistent with what we say the rules mean. So, unlike the case of ZH Bangladesh that Lord Panic took you to earlier, we aren't here referring to any discrepancy between the rules and the instructions. We're not, as it were, trying to say that the instructions should carry the day where the rules say something else or anything of the sort. We're simply saying, well, if the appellants claim there was a regular practice to one effect and the rules suggest, sorry, not the rules, the instructions suggest something different, then we must be entitled at least to show you what the instructions say.
I'm sorry. No.
Yeah.
Well, I was just going to remark that in a case which I don't think is in the bundles called ZT Kosovo, I did venture to look at instructions, not to interpret the rules, but to show what practice was. I was alone in looking at them, and I think it was I was in a minority of one in the way the whole matter should be approached, but I did do that, so to that extent, for what it's worth, it supports your approach. But then the way I was looking at the case was totally different from the way my colleagues were looking at it.
Well, I'm very grateful for that indication, my lord. I'm afraid we hadn't come equipped with your lordship's analysis in ZT Kosovo, but we will obviously...
May be entirely wrong, but there it is. It is in line with what you're submitting.
I'm grateful. I think Bennion calls it contemporaneous exposition. Well, that might be an appropriate phrase, maybe not. But, my lord, we will, of course, look at that case overnight.
Okay. I mean, as I understand it, what's said against you is between Mr. Collins and Ahmed Ali in 2000, in respect to the unamended rule, for 5 years until Mr. Justice Hodge in the tribunal, and the one we just looked at, Bangladesh, who thought that the amendment to 297 changed the picture, consistently, third-party finance was in play. People had regard to it. Yeah. Now, I mean, as I understand it, you're acknowledging that, but saying, what, that the rules actually said that shouldn't have been, or something?
Well, we're certainly saying that the rules precluded third-party support on their proper interpretation, but in terms of what happened in practice, we're saying the instructions to the relevant officials, as given out by the Secretary of State, at the relevant time, and in fact not just at the relevant time for these appeals, but prior to that, excluded third-party support. So the practice, if one can take the directions, or rather the instructions, as representing practice, the practice was consistently actually to exclude third-party support.
But even during the 5 years I've referred to?
If we go back to 1997, for example, and we can look at all of the IDIs, but yes, that would be our submission, yes.
So you've got this decision of Mr. S. Collins, wasn't the rule simply was consistently saying, oh, he was wrong, is that it?
My Lord, I accept that there was undoubtedly, that it is a fact that Ali was not appealed, and there were no doubt conflicting tribunal decisions. But in terms of what the IDIs maintained, they actually do refer to third-party support being excluded. But perhaps...
In 2004, one of the things they would consider was what other supports are available to the couple from friends or relatives in the United Kingdom.
Oh, he's got them.
Whereabouts are these?
Where are these?
It's just sitting on the side.
Oh, yes. I
Tab
see.
3, I was looking at.
So this is
My
Page
Lord,
20 at the bottom right.
so that we're taking right through from 1997 onwards.
Now,
isn't it?
can I say, it's my duty, I'm quite sure to say, that this is what my client has been able to come up with to represent the relevant IDIs for the period starting in 1997 and going up to July 2006. There isn't, I understand, a system for archiving old IDIs. Doing the best we can, we believe that these are the only relevant IDIs. But I should just give your lordships that health warning that I understand there isn't actually systematic archiving of old IDIs. Now, I don't understand anyone on the other side is suggesting that these aren't the correct ones, but I thought I should just inform your lordships of that.
As Lord Rogers pointed out, under Annex F, which is I think 2004,
April of...
yes,
Yeah.
on page 20 of the clip, the officer was entitled to consider what other support was available to the couple from friends or relatives. And then on the next page, which is the only paragraph you quote in your case, what is being forbidden is to take undertakings from third parties.
I'm so sorry, my lord.
5.1 on page 21.
5.1.
So where's the bit on page 20?
Down to the second last.
I see. What other support is available?
Yes, so it's what arrangements are from friends or relatives. Yes, I see.
In the United Kingdom, I see.
Yes.
But then the only paragraph you quote in your case is 5.1, which is a different point.
Well, it's... I'm sorry, my lord, it says this is... Yes, in referring to the possibility of an undertaking from members of their families that they will support the couple, are we looking at the same paragraph?
Yes.
It then says this is not acceptable. The rules require the couple to be able to support themselves and any dependents from their own resources. Nevertheless, such an arrangement may be accepted exceptionally if it is clear, etc. So, I'm sorry, my lord, I'm sure I'm missing
Yes,
your
I think
lordship's
you
point,
may be
but
right. Yeah.
we are relying on that simply to say, well, it does make clear that the rules do not accept support from
Sorry, is that
others.
consistent with Mr. Collins' judgment? I wouldn't have thought so.
My lord, that it probably isn't. I think
And is
it's
that
the straight-
appropriate
it's the
to
straight
issue? Is it
answer.
appropriate to issue rules that are inconsistent with the governing legislation, governing case law?
My lord, we are simply putting these forward to show what the intention remained. No doubt the parties were doing their level best to act in accordance with that judgment at the time, but the intention and policy subject, no doubt, to that was that third-party support should not be permitted. Of course, I'm not suggesting that it wasn't important to follow that judgment at the time.
The word support at the bottom, near the bottom of page 20, I suppose could be read as general support and sort of help to get employment, that kind of thing. It doesn't actually say financial support. And I suppose one could read the page 20 compatibly with 21 by reading it and reading the word support in that way.
Yes, and there's also the reference at the top of that page, just under the heading spouses.
Yes.
To parties must be able to maintain and accommodate themselves,
Well,
and
that's
then
just
the
repeating
joint income of the couple should be taken into account when assessing the adequacy of the funds available. Well, that may go to it being the joint income that one should look at. But, my Lord, yes, we would say in relation to the other reference to support that that is a rather broad reference, and that paragraph 5.1 does make it tolerably clear.
Five is general. The earnings of either party should take into to be satisfied that the couple will be able to maintain themselves and any dependents adequately without recourse to public funds. We will need to see evidence of blah, blah, blah. It's appropriate to question the couple in the following areas. It's all to do with maintaining themselves. That's the context within which this question of what support is available to the couple from friends or relatives in the United Kingdom comes in. It's the same if one goes back to 1997, as far as I can see.
My Lord, I take your Lordship's point. It may be that that reference towards the bottom of that list of things goes to the exceptional exercise of discretion in the short term that is referred to in paragraph 5.1, after the bit in bold that says this is not acceptable, etc. Because, of course, there's always a discretion to depart to some extent from the requirements of the rules. Nevertheless, the point still is there, not an acceptable long-term arrangement under the rules.
I'm looking at tab 1 here, page 4 to 5. The assistance from other sources seems to be the same guidance as we were looking at in tab 3. Is that right? That's your point, that it's been consistent all the way through.
It's been consistent. If one looks at what is actually FCO, Foreign and Commonwealth Office guidance, April 2001, that's tab 5, it is less clear at that point in relation to 317. Here you have the heading, chapter 9 on page 32, maintenance and accommodation requirements. At the bottom, paragraph 9.3, the rules require there be adequate maintenance for applicants without recourse to public funds. This means that either the applicants have their own funds or funds available to them, or a friend, relative will sponsor them. A combination of these is also acceptable. Then under the heading sponsors over the page, sponsors in the UK may themselves be in receipt of public funds. However, so long as the sponsor can show that the applicant is to be maintained without paying additional public funds, the requirement of the rules will have been met, etc. Then, in relation to... Yeah.
I mean, do we know precisely which rules this particular instruction is applying to?
I don't think we do. This seems to be very general in 9.3 and over the page. And then you get the specific reference at paragraph 9.6 to spouses.
This is obviously referring to a time before the present definition of sponsor came in, because this is 2001 or whatever it is.
Yeah.
And the present definition of sponsor, as far as I can work out, began its life on the 24th of September 2004 and was further modified on the 24th of October 2005. So
My Lord, I will...
you've got to go back to, you'd have to see what the
Double check.
definition of sponsor was,
Yeah.
presumably as at May 1994, when the current version of the immigration rules was first saw light of day.
That would seem right, my Lord. In relation to spouses, then, at 9.6, under the rules, a person being admitted as a spouse must have adequate maintenance and accommodation for both parties and any dependents without recourse to public funds. Second paragraph, when considering the maintenance and accommodation aspects of an application from a spouse or partner, is the ability of the couple to meet the requirements together, which you need to take into account. And over the page at 9.7, fourth paragraph, you again have that reference to how members of the couple's families may offer to maintain the couple, etc. However, for spouses, such an arrangement would not satisfy the rules which require the couple to maintain themselves.
And there's a qualification about limited period and so on.
Yes, which again I would suggest reflects the similar qualification we saw in the earlier IDI. And then at 9.10, you have another reference to maintenance and accommodation entry as a dependent, covering paragraph 297, 3110 and 317, which again does not expressly specify who is to maintain. So as I've said, this document is clear in relation to spouses, but I accept open to interpretation in relation to the other rule we're concerned with. But if you then move on into April of 04, and I hope you would also have in front of you October 04, which I'm afraid had been omitted by mistake from this little bundle. Should have been handed up earlier today.
Yes, we do.
Oh, I see.
Yes.
That, again, it is to the same effect. So if we go to the most relevant ones for the purposes of these appeals and what happened to these appellants, and just look at the March 06 IDI, you have the same beginning at paragraph 4 to the section on spouses, civil partners. You have the same list of matters in paragraph 5, and at 5.1, that same point about what is not acceptable under the rules.
Yeah.
And then finally, in July 06, you have the IDI that deals with paragraph 317 and others, but specifically dependent relatives, parents and grandparents. Paragraph 2, applicant must demonstrate he is financially dependent on the relative who is present and settled in the UK. Then at the bottom, note, joint sponsorship is not allowed. And then I'm afraid it doesn't really make sense. It goes on, has no other close relatives to turn to in his own country, so something has gone wrong there. Over the page, penultimate paragraph, will be maintained and accommodated together with any dependents by the sponsor without recourse to public funds. So by the sponsor, this is there. The sponsor must have the means to maintain and accommodate the applicant.
Yes. Well, is that a convenient point to
I'm sure,
stop?
certainly for my part it would be.
How
I shall endeavour to finish as quickly as possible tomorrow morning, within, say, 45 minutes or so. I think entirely within my time estimate.
Yes. And then we have, I think, 3 replies, followed by Mr. Fordham on AM2. Yeah.
Would your Lordships give thought to whether it would be necessary for those of us who are not in AM2 to be here? pleasurable though it would be to listen to Mr. Vaudreuil. I'm very happy to do so, but there's nothing we are proposing
Well,
to add.
to some extent, we'd be seeking advice from you. I mean, if you feel confident that you and Mr. Gill can both leave, I think we'd be reassured by that. We don't want to run into a position where something is said by Mr. Fordham that raises issues you'd want to comment on. So perhaps you'd like to think about that as well overnight. And if you can give that assurance to us, we may well be able to release you.
Thank you.
Thank you very much. Tomorrow morning, 10:30.
These six and this
Yes.
one.
Yes.
Are you referring to something else? Just